So a common question is, you know, what kind of speech is protected? What can you say? Well, generally, a better question to ask is what you can't say, because with the First Amendment, most things you can say. There are really a limited class of things you can't say. Probably the top of that list would be an actual threat of physical violence, especially an imminent threat. So you can't go out and just threaten people. Another thing that's covered that's similar is incitement. So saying, "Oh, go burn that building down over there." There's a case called Brandenburg versus Ohio. Says imminent lawless action is not covered. And generally, advocacy of criminal activity is not covered. Advocacy of criminal activity is a form of what they often call conspiracy. That you can't go and encourage other people to commit crimes. Certainly, obscenity is a big one. And by obscenity, what they really mean is sexual obscenity. Things such as, giving details of the what went where when while people were voti-do-doing might be an example of that, as as well as pictures, images. Now, often in today's society, these are permitted, maybe on the internet, for example, but a community can still outlaw those, so they're not always permitted. Certainly, a special class of this that is never permitted is child pornography. Another class of speech that is generally forbidden is what is called fighting words under a case called Chapinsky. Fighting words isn't quite as broad as some people think it is. In order to have the fighting words doctrine invoked, that speech must generally be face to face. So you can call somebody a bunch of bad names, but you can't do it to their face under the theory that a normal person is going to want to slug you. It's going to cause a lot of trouble. So that has been banned under the First Amendment, or can be banned by states and local municipalities. Libel and slander are more civil actions. They're generally not criminal, but there are a few states that have libel and slander laws that do outlaw certain types of speech. A big one under libel and slander is if you say that somebody has done something voti-do-doing with another person and that person hasn't. That is one of the more classic cases of libel or slander. And certainly in past days, that was a pretty big deal if you were saying about, a young woman. Another interesting area that's a little bit unique is what they call targeted residential picketing. So you generally have a right to go out on a public sidewalk and hold up a sign saying what you feel like. On the other hand, if you go in front of someone's residence in a case called Frisbee, the U.S. Supreme Court said, well, no, we're not going to allow that. Now, I don't necessarily agree with that ruling the whole way. I think generally, as long as you're not making noise, I would tend to favor saying, hey, you can go out on that public sidewalk, even though it is in a residential neighborhood, and hold up your sign. But where the Supreme Court drew the line in that one is they said that or they said technically that towns, states, and so forth could outlaw what they're calling targeted residential picketing, basically picketing that can be seen from somebody's house. On the other hand, what is protected speech? Well, ultimately, it's just about everything else. At the top of the list here is political speech. In a case called Buckley versus Valeo, okay, this is to be given the broadest protection. And often political speech is referred to as the heart of the First Amendment. And certainly that's what most people expect. I think it's intuitive that most people will understand that. Unfortunately, there's a few officials in Wimber Borough who don't. But generally, I think most people understand this very well. So, what else? Well, other types of speech or expression, movies, videos, books, films, websites. All of these are types of speech. Some of these also touch towards media. Website, it blurs the line these days. What is media? And certainly many traditional media have been replaced these days by podcasting, by people posting on, for example, Rumble, which is a free speech site. You have creating the speech as well as showing the speech. So it's not just showing the movie that counts as free speech, it's you have a right to create that. Okay. Certainly, as I mentioned before, expressive conduct is considered speech. Flag burning, okay, nude dancing. These things are generally considered expressive. You're trying to make a point often. So these things are often considered speech. Swearing. So in the classical case, Cohen versus California, a gentleman was not pleased with the Vietnam War. He was in a public courthouse. He had a jacket on that said F the draft. You understand F is the little four-letter F word. He said F the draft, or his coat, his jacket did. And that went to the US Supreme Court, and in a 5-4 ruling, the Supreme Court said that is also protected speech. A surprising one here is advocating the overthrow of the US government. So while you cannot say, go burn down that building over there, you can basically say, well, this is all bunk in the US. I don't like it. I think we should, have a revolution. That was basically ruled legal in Brandenburg. In some ways, that's understandable if you consider that's what our founding fathers did. They said that the English government was all bunk and they got rid of it. And then another one here, finally, is censorship. Censorship is generally considered a form of speech, or it's non speech, but in other words, it's your ability to not say something. Now, there are limits here for censorship. Great example is telegraph companies. You don't think about telegraph companies these days, but they're in the same boat as phone companies. Phone companies cannot listen in on your phone calls and pick out which ones they're going to transmit and which ones they're not going to transmit. Telegraph companies were once the only game in town, and they used to do that. They would not transmit things that they disagreed with their political opponents. And the U.S. Supreme Court stepped in and said, no, you guys are common carriers. And the U.S. Supreme Court is in the middle, very hopefully, of also saying that for the big tech firms. And the big tech firms are just notorious for censorship of differing political viewpoints. So generally, most things are covered. There is one area that's sort of in the middle here of speech, and that's commercial speech. Commercial speech generally is referred to as having diminished protection. So ultimately, if you want to say it, you have a limited number of things you need to worry about, but there's a heck of a lot you should be able to say that you can say in most areas, but apparently not Wimber Borough. So I wish you a great day.